Good afternoon, everybody. Welcome. I appreciate everyone chiming in and viewing this webinar. My name is Samuel Bergsohn. I am an attorney with Jacobowitz and Gubitz. It is June 16th at 4 o'clock in the afternoon, and I'm excited to discuss with you the landlord tenant proceedings in New York State and the impact of COVID-19. I appreciate everyone who signed up and is watching. Just to very quickly, Jacobowitz and Gubitz. We are a full-service law firm. We operate in Walden, New York, and in Monticello, New York. We have been serving the Hudson Valley for over 50 years. We have over 20 attorneys and full support staff. We could service any and all of your legal needs. So if you have any legal issues that need to be addressed, don't hesitate to reach out to the firm, and we can certainly help you. We have been conducting meetings via Zoom virtually for the past several months, and so we're fully capable of handling any legal needs during this time. I'd like to say I appreciate, again, everyone who's signed up. You can ask questions throughout the webinar. I will try and address them as they come in. If I do not address them as the questions come in, please be patient, and I will address them at the end after I've gone through all the slides. So I will address any questions you have. Feel free, anything that comes to mind, go ahead and bring it up. I also want to mention that for anyone who's viewing this webinar today, you are entitled to a 15-minute free consultation with the firm to discuss landlord-tenant matters. So I'll address more how you can go about getting that consultation at the end of the webinar. But please, if you have any potential issues, reach out. We can set up that consultation, and I'd be more than happy to discuss any individual legal issues that you're dealing with. Now I'm gonna start getting into the substance. And landlord tenant proceedings in New York State are summary proceedings. A summary proceeding is an expedited process through which a landlord may evict a tenant. Now, these are justice court proceedings that take place before a local court in the town or the village. And so you're going to be in a small court. It's going to be a small court, a judge in a small room. It's not going to be a large county court procedure. It's going to be a more intimate process. Summary proceedings, being a statutory creation and not a common law right, must comply precisely with the statutory requirements. Otherwise, a dismissal of the proceeding on jurisdictional grounds might result. Now, to translate that legal quote, really what's going on is the process for evictions in New York State has been set by the legislature. The legislature has created the process, and it's a very complicated process, and you need to follow that process. So if you don't follow any of the steps perfectly to the law for a landlord-tenant proceeding, if you're a landlord, you will be at risk of having your action dismissed. So evictions in New York are very complex. And as I just said, landlords, they need to navigate an increasingly complex web of rules and regulations surrounding landlord-tenant proceedings in New York. Landlord-tenant relationships and evictions are generally governed by Real Property Law Article 7 and Real Property Actions and Proceeding Law Article 7. So it's important just to make sure that if you are a landlord and you're bringing an eviction proceeding, you need to follow the notice requirements, follow the service requirements to a T. If you're a tenant and you're subject to an eviction proceeding, make sure that your landlord has followed those proceedings. Otherwise, you might have an affirmative defense. So the next question is how does someone entitled to possession bring a summary proceeding? And so we're looking at what types of people can bring a summary proceeding. Who can bring a summary proceeding in New York State to evict a tenant? And of course, a landlord, an individual who has a contract lease with a tenant, they would be entitled to bring a summary proceeding. A purchaser at a foreclosure sale can bring a summary proceeding if someone remains in the property after they take ownership. And a lessee entitled to possession. So if you have a situation where you're subletting an apartment and you would like to evict the subletter, you can use the summary proceeding process in New York to evict a subletter and any other persons lawfully entitled to possession. It's laid out by the statute, and anyone else who lawfully is entitled to possess the property is entitled to bring an eviction action to remove that tenant. Now, at a minimum, the following papers will need to be served by the landlord on the tenant and then filed with the court. So what papers need to be filed by a landlord to start a summary proceeding? The first thing that a landlord needs to have is the preliminary notice. And that preliminary notice needs to be served on the tenant. So the preliminary notice, and it's either going to be a notice of termination for a holdover matter or a notice of non-payment for a non-payment matter. And I'll go into those two types of proceedings more in depth later on. You will need, as a landlord, to send out the preliminary notice saying either your tenant's lease or tenancy has been terminated or that they haven't paid and it's a notice that they need to pay. That's a requirement for any summary proceeding. Next, you are going to need to have a notice of petition and a petition prepared, served on the tenant, and filed with the court. The petition is essentially the landlord's complaint. It outlines the law, it outlines the facts, and it outlines the justification for why that landlord is bringing the summary proceeding to evict their tenant. The notice of petition is going to clearly state the date of the court appearance, the time of the court appearance, and the location of the court. Those items will be served together on the tenant before the court appearance. And so now we'll move on to the grounds for an eviction in New York. Who can be evicted? A tenant is a person occupying or entitled to occupy a residential rental premises who is either a party to the lease or rental agreement for such premises, or is a statutory tenant pursuant to statute. So we'll discuss in depth, like I said, the non-payment holdover proceedings, and then there are certain other grounds where a landlord-tenant relationship does not exist, where an owner of a property is going to need to use the summary proceeding process for an eviction. But a tenant is really someone who's been occupying the premises for over 30 days. It's important that the tenant has been in that premises for over 30 days before you need to proceed with the summary proceeding to have them removed. So 30 days is kind of is really the threshold. If that individual hasn't been there for 30 days, you might be able to reach out to the police and say, there's someone unlawfully in my property. They might not be willing to assist you. They might be willing to assist you, but the law really says that a person gains tenancy status after 30 days being on the premises. Now, I'm going to pivot. I'm going to address, because I think it's probably something that most participants for today's webinar are most interested in. I am going to address the impact of COVID-19 and the ongoing pandemic on landlord-tenant proceedings in New York. I've had a lot of experience these past few months in dealing with the governor's executive orders, and I have a full understanding of what's going on, some things that still remain confusing, and the directions that have been provided by the state. So let me go through it, and I'll start on March 20th, 2020. Governor Cuomo issued Executive Order 202.8, which stayed all evictions in New York State and executions of warrants through June 20th for 90 days. From March 20th to June 20th, there weren't any evictions allowed, and there are no warrants that can be served to evict a tenant. So we're coming up on that June 20th date, and in the past 3 months, no evictions have been allowed. It's pretty straightforward, the executive order. On May 7th, the governor extended the stay on evictions through August 20th. However, it's only for non-payment cases where the tenant has been directly impacted by the COVID-19 pandemic. So how does the tenant make that showing to the court? The governor has not provided any further direction yet on how the tenant would go about showing to the court that they've had a hardship from COVID-19. Personally, in dealing with the court, I haven't seen any direction locally, county, or at the state level that has provided direction to the justice courts how they're going to proceed with this directive. So you will need to stay in contact with your local court, whether you're a landlord or a tenant, and you're going to want to see whether or not they're going to require the landlord or the tenant to make that showing of a hardship, and whether or not they're even going to entertain any eviction matters at all until August 20th. Now, moving on, just addressing on March 15th, there was also a memorandum that was provided by the chief administrative judge for the New York Unified Court System. So effective March 16th, all eviction proceedings and pending eviction orders were stayed until further notice. And there hasn't been any subsequent memo from the state since that March 15th memo. So as of today, justice courts really remain shut down. I have not seen any justice courts in Orange County open up for any landlord tenant proceedings to take place. I do know that in the city of New York City, there has been a directive that for all landlord tenant matters where the landlord and the tenant are represented by counsel, they have scheduled conferences for those cases, but that's only been in New York City. And my webinar today is really directed at landlord tenant issues outside of New York City. And outside of New York City, there has not been any direction for the justice courts to resume with any landlord tenant proceedings. There has been a resumption of filing of essential matters, but because of the memorandum that all evictions have been stayed, they haven't been accepted at the Supreme Court level, any eviction filings. So there's really a continuance of that stay of any evictions currently. How the administrative order coincides with the governor's executive orders, right now, there's really no direction in that regard. So you have the chief administrative judge who's saying all evictions have been stayed. You have the governor who's saying all non-payment evictions for individuals have been impacted by COVID are stayed through August 20th. Right now, most justice courts are going with the approach that they aren't going to hear a case until at least August 20th or until they have further instruction from the chief administrative judge. So that's where we stand currently in terms of being able to bring a summary proceeding for an eviction in justice court. I do want to cover another aspect of the governor's executive order. This is from 202.28, and it addresses security deposits. Now, tenants who are facing a hardship may elect to have any security deposit held by a landlord applied toward overdue rental payments. And if they do so, the following conditions will apply. The agreement must be in writing. The tenant must replenish the deposit at a rate of 1/12 the amount used per month. The agreement must cover the entire amount due, otherwise the remaining amount is waived. And the repayment shall not become due until 90 days after the security deposit is applied to rent. So this is going to provide some relief to tenants who want to use their security deposit toward rent. The landlords are going to have to acquiesce to that tenant's desire if they so choose to do that, and they must abide by the conditions outlined just now that are outlined in Executive Order 202.28. Moving on, just what can landlords and tenants do now during these times? Obviously, there's a lot of uncertainty. I basically explained that there's still a large amount of uncertainty from the memorandum from the court system and from the executive order from the governor. So what should landlord and tenants do? Talk to each other. Tenants who have been impacted by the hardship need to have a conversation with their landlords and let them know. And landlords who have tenants who they would likely presume might be impacted by the hardship should talk to those tenants and see what can be done so that the landlord-tenant relationship can go smoothly and can continue going forward. Now, landlords are not prevented from sending out the preliminary notices at this time. There haven't been any directive from the governor or from the court system that says that landlords are prevented from sending out a notice of termination or a notice of non-payment. So get your cases started if you're a landlord. Just send out your notice. Let that tenant know that you have the intention to proceed with an eviction, and you can let the tenant know that you're still willing to have a conversation with them, but you're not prevented from getting that notice out. And tenants also need to be aware that these payments are not being forgiven. Evictions might not be able to proceed through June 20th or August 20th or an extended date if that's pushed out farther, but tenants are still going to be required to make those rental payments. That lease agreement is a contract between your landlord and you. There hasn't been anything that has waived those rental payments. And so even though you might not be able to be evicted for some time, those payments will remain due and owed to the landlord. So keep that in mind for any tenants who might have confusion in that regard. Now, I'm just going to quickly run through some of the specifics for non-payment and holdover proceedings. They are the most common forms of summary proceedings, eviction proceedings in New York State, and there are some very specific facts about both of them that I'd like to go over with you. Just looking at non-payment proceedings. Non-payment proceedings are summary proceedings that are initiated by a landlord against a tenant who has not paid the agreed upon rent. It's pretty straightforward. It's a non-payment proceeding. Now, a non-payment proceeding is going to require two notices. It's going to require an initial 5-day non-payment notice. That's going to be a notice that you have to send as a landlord to the tenant if within 5 days of the payment due date for that month or that year, if within 5 days you haven't received payment, you have to send a notice to your tenant advising them that you haven't received payment within 5 days. Then you're going to be required to send a 14-day non-payment notice. The 14-day non-payment notice says to the tenant, you have 14 days to remit the payment due. Otherwise, I'm going to initiate a summary proceeding as the landlord to remove you from the premises. Now, a non-payment proceeding can be cured by the tenant at any time up until the eviction, as long if they make a payment to cure any past due monies owed. So if a tenant owes for 3 months, they go to court, they lose, the judge signs a warrant of eviction, an eviction date is set. At any point up until the sheriff comes to execute that eviction warrant, the tenant can make a payment to cure, and that would dismiss a summary proceeding and they can remain in the premises. It's very important to know that. And I do also want to cover that recently in the summer of 2019, the laws changed regarding non-payment and holdover proceedings in New York. And so if you're online and you're trying to do your own research about a landlord-tenant matter, you might be looking at the wrong information if that website or article was published before July of 2019. And so, for example, I said there's a 14-day non-payment notice that's required. That was recently changed from a 3-day non-payment notice, which is a drastic change that the court initiated. And also, it's important to note that for a non-payment proceeding, a tenant has 10 days to file an answer, and that's been changed from 5 days. So the legislature has definitely instituted some pretty tenant-friendly aspects to the landlord-tenant process for non-payment proceedings. Now I'm going to move over to holdover proceedings. And again, a holdover proceeding should be somewhat self-explanatory in that the tenant is holding over after the expiration of the lease term. And so if that's the case, the landlord is going to be entitled to bring a summary proceeding to remove that tenant from the property. Now, the notice of termination, the preliminary notice is going to be a notice of termination that needs to be sent to the tenant, that needs to be served on the tenant before the summary proceeding can be initiated. There are very specific requirements, and these have also been amended as recently in summer of 2019, that landlords and tenants should both be aware of in a holdover proceeding. If that tenant has been in the property for less than 1 year, only a 30-day notice is required. If the tenant has been holding over after being in the property for between 1 and 2 years, a 60-day notice of termination will be required. And if the tenant has been in the property for over 2 years, a 90-day notice of termination is going to be required. And again, as I outlined early on, summary proceedings are statutory proceedings, and you need to follow the statutory requirements to a T. So if you send a 30-day instead of a 60-day, the judge, he might not even need to hear a defense from the tenant. The judge might dismiss it on his own. And you need to, so you need to, as a tenant, comply with those notice requirements. And as a landlord, you need to comply with those notice requirements. And as a tenant, you need to be aware and look into whether or not the tenant has complied with those notice requirements. Another very specific and particular aspect of a holdover proceeding is that the notice of petition and petition need to be filed with the court between 10 and 17 days prior to the court appearance. And so what needs to be done is you need to, as a landlord, you're gonna need to reach out to the court, get a court date, serve your notice and petition on the tenant, and have those papers filed with the court between 10 and 17 days before the court appearance. It can be a very difficult requirement to meet if there are multiple tenants and if issues with service arise. And so tenants need to be aware and look into whether or not the filing complied with the time requirements, that it was within 10 and 17 days before the court appearance. And if it was not done properly, the tenant will have an affirmative defense that they can raise. Now, keep in mind, if a tenant raises an affirmative defense and the judge dismisses a summary proceeding against the landlord, that landlord is going to be entitled to bring the action again, but they're just gonna have to go through the process of re-noticing the tenant, resetting a court date, and it'll take time. So landlords really need to be aware, and tenants really need to be aware of these requirements when a summary proceeding has been initiated. Moving on, I'm going to now very quickly just address grounds for eviction where no landlord-tenant relationship exists. And really just to pinpoint what that means, if there's no landlord-tenant relationship, that tenant, there are certain situations where they're not really a tenant, they're not entitled legally to be on the premises. And when that happens in New York, oftentimes it's the case where a summary proceeding will still be required to remove that individual. Now, the most common situation where that arises is a squatter. And I think most people are familiar with the term a squatter, someone who kind of just finds, you know, a building, a home, a premises that's been abandoned or is vacant without permission. They enter that property and they just set up shop and they begin living there. Now, if that's the case, the owner of that property is not going to need to serve a 30-day or a 14-day notice. They'll only need to serve a 10-day notice to quit on those individuals that are in the premises. And then they can bring a summary proceeding and have that person removed. It's difficult for an owner if all of a sudden they find out that someone is in their property, that they need to go through a legal process, but that is the requirement in New York if you want to remove a squatter or a holdover after a foreclosure sale or any other potential licensee whose license might have expired or been revoked. And so if you think you might have a situation like that, reach out. We can go over it and see if it's a 10-day notice to quit that you would need to proceed. And so now moving on, from a tenant's perspective, if you're served a petition, a notice of petition, and you have a court date, how does a tenant respond to a summary proceeding against them? So what papers would a tenant need to file? Well, a tenant may, but does not really need to file any paper answer. As long as the tenant appears on the date and time at the courthouse identified on the notice of petition, the court is going to give that tenant an opportunity to answer the petition and is going to let them do that orally before the judge. the court is not going to default a tenant who appears at the court proceeding. If the tenant does not appear, then the judge would very likely enter a default judgment in favor of the landlord. But if the tenant appears, they will be entitled to answer the petition. Now, the most common and successful defenses to an eviction proceeding for a tenant is, of course, in a non-payment proceeding, if they do remit the payments due, then that will dismiss the action. If the landlord failed to follow the specific notice requirements outlined in the statute, the tenant will have an affirmative defense that they can raise to have the action dismissed. And then also, if the landlord has breached his warrant of habitability, in which case the landlord has created an unreasonable living space for that tenant, the tenant will have a defense to the eviction process and will be able to prevent the eviction process from going forward. So those are the most common defenses. Now, I had mentioned previously that there were some recent changes in landlord-tenant law. And in July of 2019, the Housing Stability and Tenant Protection Act was signed into law by Governor Andrew Cuomo. This had extremely large ramifications on landlord-tenant proceedings throughout the state. It basically touched on almost every aspect of landlord-tenant proceedings. The laws as passed were very tenant-friendly. The legislature wanted to provide more protections to tenants throughout the state, and they certainly did that. Some of the more relevant provisions is that all tenants are entitled to a 14-day mandatory adjournment if they make an initial appearance at the court on the date identified on the notice of petition. So if you're a tenant and you're served with eviction papers and you appear at the court on that date identified on the notice of petition, you are entitled by law to one adjournment. That adjournment has to be a minimum of 14 days. The judge has to grant you that adjournment as a tenant, and that will set the case for a trial. Essentially, you'll be setting it for another appearance, in which case a trial should take place. That should be the procedure that's outlined by the judge, and that would be a small trial in the justice court, in the local justice court, where you will try the facts of the summary of the landlord-tenant case. Another very significant provision of the HSTPA of 2019 was that you can only collect as a landlord fees for use and occupancy. Any other fees for attorney's fees, late fees, fees for damage done by the tenant, they can no longer be collected in a summary proceeding where you're trying to evict a tenant. You can only collect the fees for the unpaid rent. And so if you do have other late fees, damage fees, attorney's fees that you're interested in collecting as a landlord, you're going to need to bring a separate action against the tenant to get a judgment to collect that amount. And so that's another very tenant-friendly law that was an aspect of the act that was submitted, that was passed in July of 2019. Warrants of evictions. I see there are a couple of questions. I will address them. I'm almost done with the substance of the presentation. So very quickly, warrants of eviction may not be served for at least 14 days after the order is entered. That was an increase previously. It could have been served, I believe it was 3 days. If you need, I can clarify, but now it's 14 days. And the court has direct discretion to issue a 1-year stay of any warrant of eviction that's signed. And so if a tenant comes to court and asks for that warrant of eviction to be stayed, the judge in his or her discretion is entitled to give 1 year to that tenant to remain in the property. It seems kind of draconian, and I haven't seen any judges institute that long of a stay. I haven't seen judges really institute any stays to too often for a warrant of eviction, but that is something that they are entitled to do. So those are the most relevant changes in the law. The law really had many aspects. So if you do, you can look online. There are a lot of resources that outline the other changes made, done by the Housing Stability and Tenant Protection Act. And if at any point you'd like to discuss the act further or the implications thereof, you can definitely reach out and I'd be happy to discuss that with you. So I've taken my 30 minutes of time to cover the substance very quickly before I address some of the questions, and I will. I just want to cover the firm's June upcoming webinar series. This is the first webinar in June that we did. There's also on June 24th going to be a webinar presented by Michael Wagner on estate planning and asset protection. And then on June 30th, the firm will be conducting a webinar on the pros and cons of bankruptcy, which will be conducted by Martin Butcher. And going forward, we anticipate that we're going to have many future webinars. So we really look forward to involvement and, you guys participating and letting other people know who might be interested, because we're really going to provide informative webinars that, really can help anyone out there in the community going forward. Now, as I had mentioned in the beginning, any webinar participants, anyone viewing this webinar, you are entitled to a free 15-minute consultation at your convenience. Just reach out to the firm and you can set up a time, and I will touch base. Most likely, I will be the one touching base with you, and we can address the specific facts that you're dealing with, whether or not as a landlord or a tenant you have a case or a defense. And I'd be more than happy to provide you my expertise and to discuss with you anything regarding landlord tenant law that I've covered today, or maybe that I haven't covered today. And so that's really it on my end. Let me address a couple of questions here. So I'm going to go through them in order. It looks like they came in pretty recently. Dina, I have requested via email my security deposit be applied for current month's rent on May 29th, 2020 to the site manager. I asked her to provide amount of principal and interest that will be used. I have not received a response. I indicated that I will pay next month's rent. Thank you. So your site manager is, as I outlined, required by law to apply the security deposit to the rent if you wish. And they are required to set that down in an agreement in writing that's outlined by Executive Order 202.28. So if you advise your site manager of that, they should follow the procedure and provide you an agreement in that regard. If there are any issues in that process, certainly reach out and we'll see if we can assist. But that's pretty straightforward. The executive order is not, it's not confusing in any way. That's pretty clear in the executive order. Looking at the next question, if there are filing errors by the landlord and the tenant raised an affirmative defense, is the judge obligated to dismiss on that technicality, or can the judge allow the proceeding to continue? So my answer to that is it depends, and it's going to depend on what the filing error is. So, for example, I said that in a holdover proceeding, the notice of petition and petition need to be filed with the court between 10 and 17 days before that initial court appearance. If you file with the court on the 9th day before the court appearance, then the tenant will certainly be able to raise that as an affirmative defense, and the judge will certainly have to dismiss the case if the tenant does so. Now, when you say there's a filing error, if that filing error is something that's not covered by statute, and I'm trying to, rack my mind and think if it's a filing error where, maybe there was a typo in a plaintiff's name, or there was some other legitimate mailing issue where a mailing was sent properly and got lost. A judge might be able to continue the proceeding, but if it's a statutory technicality, if it's a technicality, if it's an error that's directly addressed by statute, that's the judge is going to have to dismiss. Where does a landlord sue for damages such as attorney's fees, damages to the premises, late fees incurred, etc.? It's a great question. And it's going to depend if it's a small amount, small claims in the local jurisdiction, that local court, that's probably the venue that you're going to want to bring the case. You're going to be entitled to bring that case there. If it's in excess of the amount that's being demanded, if it's in excess of the limitation for the small claims court, for the justice court, you might be required to bring that case in Supreme. So it's going to matter on how much you intend to sue for the damages, for attorney's fees, etc. So, if you have that question in that regard, reach out. We can look into what the limitations are and where the proper venue would be. Service requirements for the 30, 60, or 90 days notice. There are no service requirements, no particular service requirements on the 30, 60, or 90 days notice. It's advised that you get personal service on the tenants so that they can't raise any issue that they weren't served. If you don't get personal service, there's always the potential that service issues can be raised, but I would say there aren't any other particular service requirements on the 30, 60, or 90-day notice. Will we be emailed the materials in today's webinar? We'd be happy to do that. I will look into whether or not we can get that provided to the participants. If you want the materials, just shoot me an email directly. My email, and I don't know if my screen is blocking it. Let me move this over. So you can see my email address. It's not on here. My email is scb@jacobowitz.com. So if anyone wants the materials today, I'd be happy to provide it. We'll try and post it on the website. This video the webinar will be posted on the website, and we should post the materials with that as well. So you should be able to get that. If you want it, just reach out to me directly. Are these rules the same for commercial? In particular, notice to vacate from the tenant. I had a lease prior to June 2019 requiring a 60-day notice. I got 12-day notice before the lease expired. Lease required 60-day notice if they were not going to renew. So there are some, this webinar, and I want to be clear, was focused on residential landlord tenant proceedings. There are certain requirements for commercial proceedings that are not the same as with residential requirements. Right now, most of the points that I covered are consistent, residential and commercial. Regarding your specific question, if the lease required a 60-day notice that they were not going to renew, that is something that I'm fairly certain that statutory, there isn't any, I don't believe there's any statutory language that would alter the lease term. So if the lease said 60 days on a commercial notice to not renew, I'm fairly certain that commercial tenant needed to abide by that term of the lease. But Christine, if you reach out to me, I will be happy to look into that further and address it for you. How much time does the tenant have to serve an answer under the new laws? So technically in a non-payment proceeding, if a tenant doesn't answer within 10 days, the judge is supposed to enter a default. However, if that tenant appears in court and orally answers the petition, I couldn't imagine a judge defaulting that tenant even though that's a statutory requirement. And that's from my personal experience. Very rarely have I seen tenants file and serve a written answer. Almost always they're coming to court with an oral answer, and I've never seen a judge just, prevent them from answering because they exceeded the 10 days. Can we now charge pet security? Can we include extra in the rent if one has a pet, not assisted nor support animal? Here's what I would say, and I've had experience with this. I would draft a separate pet security agreement that's not a part of the lease. That should be a binding agreement. I have seen some attempts to challenge pet security agreements in the state recently, but if you draft a separate security agreement for the pet, that should hold up. It almost certainly won't be able, almost certainly won't be able to collect that, bring any action against a tenant I take a separate agreement on a pet security, for a pet security agreement should be acceptable. Can you recover attorney's fees in the civil suit following the eviction? You can. Now, there have been some limitations on that as enacted by the new law, but you should be able to bring a civil suit to collect, like I said, late fees, attorney's fees, and damages from the tenant. Last, I'm seeing it's important we get materials. Absolutely, we'll make those available. The webinar and the slides we will definitely make available. How do you enforce a pet security agreement if it's outside of the lease? So that's going to be a contract agreement that you would need to enforce. It would still likely be in housing court. You would, if there's a breach of the pet security agreement and you want to remove that tenant, you would bring that tenant to court. It would be, it's not, like I said, it's not too common, but that's the procedure that I've seen most judges and secondary and legal scholars advise. It is a change. Pet security agreements is seems like it's a somewhat fluid area right now. So Nanette, if you want to reach out, I'd be happy to, go over that more in depth with you. I think that's it. I will sit on for another couple of minutes in case anyone wants to have any other questions. I really enjoyed conducting this webinar, and I hope everyone got some good information from it. If you need anything at all, again, don't hesitate to reach out. We have a wonderful firm here. We've been in the community in Orange County for over 50 years, and so we're a very trusted firm. If you need anything at all, don't hesitate to reach out. I hope to see you all, speak to any of you soon. I actually don't hope to speak to some of you soon because that would mean that you wouldn't have any landlord-tenant disputes. But if you do, don't hesitate, reach out, let me know, and we'll see if we can help. Thank you so much, everybody. Thank you very much. Oh, well, let me see if there's one more. Awesome. Thank you, guys.